Morning, Your Excellency. My name is Bryan, and I'll be dealing with Naira's failure to ensure the rights of the Kispe sisters with regard to the forced slavery and gang rapes that occurred in the SMD in the 1990s, as well as the series of assaults on Maria Kispe in 2014. To this end, I'll be making two submissions. First, Naira's domestic limitation period does not excuse their failure to investigate and punish the breaches of the Kispe sisters' human rights. And second, Naira's failure to take any actions to investigate or prevent the series of brutal assaults by Jorge Perez is a breach of Maria Kispe's right to humane treatment. Turning to the first issue, Naira cannot rely on its domestic statute of limitations to excuse its breach of its obligation to investigate and punish the forced slavery and gang rapes that occurred in 1992. The obligation to investigate arises from the state's Article 1.1 obligation to ensure the rights contained within the Convention. In the seminal case of Velasquez-Rodriguez, this court held that the obligation to ensure consists of three positive obligations: to prevent, to investigate, and to prosecute violations of Convention rights.
How does the domestic law stand in relation to the treaty obligation? So the fact that the treaty obligation is there and that there's a requirement to investigate as soon as possible, I suppose, or soon as is reasonable. How does that stand in relation to a time bar?
Your Excellency, it is our submission that the domestic statute of limitations cannot excuse a failure to investigate because the state, because as per Article 27 of the Vienna Convention on the Law of Treaties, states cannot invoke provisions of domestic law as justification for failure to perform a treaty. This position is consonant with this court's holding in the Bulacio decision in 2003 that any domestic legal obstacle that attempts to impede the investigation and punishment of those responsible for a human rights violation is inadmissible. In that case,
on the other hand, though, wouldn't it be more consistent with the treaty obligations in that the idea of having unprosecuted crimes as a sort of Damocles over the alleged perpetrators is itself some kind of a breach of the human rights obligation, such that a limitation period would be one that may actually protect everyone, such that there's a time frame beyond which people have to acknowledge that they just have to work on recovery, rather than recovery and reconciliation, rather than prosecution and punishment.
Your Excellency, just to clarify your concern, you're concerned that to ignore a statute of limitations may be a breach of the accused rights as well.
Yes.
And a secondary concern, which is that the state should be more concerned about reconciliation at a later stage after such an extended period of time has passed. I'm
not necessarily saying that it is something that they should be more concerned with, but I'm saying that isn't it possible to consider the treaty of limitations or the statute of limitations as part of the whole package of obligations under the human rights treaty?
Your Excellency, I'll take your questions in reverse order. With regards to whether or not the treaty obligations do take into account the statute of limitations, in fact, the treaty does not contain any express statute of limitations within the document itself. And as per paragraph 6 of the agreed facts, Naira is a monist state, and these treaty obligations take constitutional status within Naira.
Yes.
And to go back to your first concern about the rights of the accused, it's submitted that court proceedings should be able to take into account the prejudice against the accused person. For example, if we're concerned with bad evidence, the court can choose to award however much weight to the evidence as the case may require or the case may be, and that would not be in breach of the accused's right to fair trial. In fact, the Article 8 only requires an equality of arms, and in fact does not prevent the state from using old evidence against the accused person. So the argument that a domestic statute of limitations does not apply in the present case is buttressed by the fact that there are certain violations of human rights which are tolerated by the state, and this court has held that in those situations, the obligation to investigate and to punish acquires a particular and determining importance. In the present case, it is submitted that the state's conduct in approaching the violations is indicative of a tolerance towards these violations. First, the state has not investigated these events. Second, the Truth Commission suggested by the state does not have the legal capacity to impose punishment for the breaches found. And third, the state has not expressly denied the occurrences of the events, they've only denied responsibility.
Yeah.
In light of these facts evincing the tolerance of the state, it is submitted that the obligation to investigate cannot be extinguished by a domestic limitation period. And thus...
Sorry, are you talking now about the violations that occurred in 1992 or in 2014 at this point?
In 1992, Your Excellency.
Okay.
Thus,
why should the state be held up to these standards given that these matters were not reported until 2014? So, what is your justification for the delay, given that the delay was from 2014 onwards, correct?
Yes, Your Excellency, the delay from 2014 onwards regarding the 1992 breaches?
Yes. So there's no delay, right, in a sense? I mean, so your second argument is the failure to investigate is the violation, right? Mm-hmm. Your first argument is that they cannot rely on a statute of limitations, right? So if I were to accept the statute of limitations argument, there wouldn't have been a delay because they had a legitimate basis not to investigate because they, in good faith, believed that they were time barred, right?
Your Excellency, I think the two submissions need to be taken together in that in relying on the domestic time bar to excuse their breach, to excuse their obligation to investigate is in and of itself a breach.
No, but if they in good faith believe that there was a time bar that operated, then whatever the delay is suspended from the time that they relied on the time bar as a reason for not investigating and the decision that we make today, right? So, in essence, what is the period of delay? We're looking at December 2014, after the interview ad, right? And up to the time when in March, no, actually, wouldn't it be from March 2015 onwards, in that the criminal complaint was only filed in March 2015, right? Up to the time that the executive branch replied, which means that it is actually, there was no delay at all, because in fact they were of the view that there was a time bar, right?
Your Excellency, there is no indication of the facts that NIRA has any intention to commence any sort of investigation because they have denied responsibility. They, in paragraph 33, it says that the criminal complaint is time barred and they have taken no further actions to investigate and prosecute in judicial proceedings. But they have actually
gone on to establish a high-level committee, right?
Your Excellency, it's our submission that this high-level committee is not a sufficient substitute for a judicial proceeding.
But it is about exploring the potential reopening of the criminal cases. So aren't we actually somewhat premature? And he also announced, the president also announced the creation of a special fund for reparations, right? So essentially, it's not that the state is not taking action. It is the state is not taking the kind of action that Kilapura wants. But surely, Kilapura is not the one that should make arguments as to the appropriate action to take. I mean, we're talking about violations that only surfaced very recently, and for this case to be brought before this court, before the state has had a chance to really consider what appropriate steps to take are, is somewhat premature, right?
Hmm. Your Excellency, it is the petitioner's case that although it may seem premature insofar as the state is taking certain actions, it's submitted that even taken at its highest, these actions do not fulfill the obligations under the treaty. Specifically, the treaty obligations require the state to punish violations of human rights. However, there's no indication on the facts that any of these proceedings will result in punishment, especially I'm referring to the Truth Commission specifically. If we do not consider the reopening, if the state does not reopen the criminal cases in judicial proceedings, then it will eventually result in merely a finding of fact through the Truth Commission and will not have the necessary punishment of the violations as required by the treaty. Your Excellency, if I may turn to my second issue, which Naira has failed to ensure Maria Quispe's right to humane treatment. They have failed in two ways. First, they failed to investigate the first assault on 20th of January 2014. And second, they failed to prevent the subsequent two assaults which occurred in May and August 2014. I'll be dealing with these two issues separately. Naira has breached its duty to investigate when it failed to take any action whatsoever after Maria Quispe reported her husband for disfiguring her with a broken bottle. The obligation to investigate arises once the state is aware of a potential human rights violation and requires the state to initiate officially and without delay a serious, impartial, and effective investigation.
But here there was no police report. So in the absence of a police report, the prosecutor is unable to bring charges. So why are we blaming them for their own internal problem? So actually, on the whole, it does seem that the application here on the part of the complainants seeks to impose on the Republic of Naira obligations that are far and above what they are capable of, right, given their circumstances.
Your Excellency, it is our submission that this standard of investigation is one that the state has agreed to when it became a party to the American Convention on Human Rights, and therefore should apply as a matter of law, given that the state should be held accountable to its international obligations. The fact that the state is unable to, or the state may be unable due to certain restrictions on its resources is, although should be taken into account.
Would you rather that the state not be party to a treaty because it can't meet the obligations, or would you rather that the state be party to a treaty but that its obligations be, or the manner in which it meets its obligations be considered in light of their capabilities, you know? So under the circumstances, it sounds like we are, even if we only focus on the 1992 events, we are judging the state very, very harshly because we appear to be imposing on them standards that even other parties to the Inter-American, the American Convention on Human Rights are unable to abide by.
Your Excellency, it is our submission that it is better for a state to sign up for the treaty because the obligation under the treaty is just that of due diligence.
Yeah.
And the obligation is one of means and not results.
Yeah.
As long as the state can show that it had taken all the possible actions within its own capacity, it will have discharged its duty.
Correct. So essentially what's happening here, even in relation to the 2014 incidents, and we're really talking about domestic violence, we are also looking at situations where, you know, in other more developed countries in Europe and in North America, that, you know, domestic violence cases are often not managed in the way that they ought to have been, such that there are continued violations of women's rights when it comes to domestic violence, because it is a very difficult situation to deal with. So what you seem to be asking for in relation to the 2014 violations is that they should disregard their own procedure, right? And disregard the need for medical examination before the prosecutor takes action. That's somewhat harsh, don't you think?
Your Excellency, we're not asking the state to disregard the medical examination. It is our submission that there exist many alternative actions that could have been taken by the state.
But which requires a change in their law. Are you asking for a change in their law, or are you asking for special treatment to be given to this lady? Because it appears to me that what happened here is that they have a framework, they have a structure, and that framework and structure is one that requires a police report in respect of domestic violence to be supported by a medical examination before the prosecutor takes action. And here we're really talking about an inquisitorial system, it looks like, where you need to constrain the powers of the prosecutor, otherwise there would be all sorts of egregious sort of abuses of the rule of law, right? If you don't actually have proper evidence before action is taken. So, coming back to the original question, are you looking at her specific case, or are you looking at the general legislative framework or regulatory framework that has to be changed?
Your Excellency, in our written submissions, we address both your concerns. First, that the state's investigative framework is insufficient to meet its international obligations. And the second, that with regard to the specific case of Maria Quispe, they have breached her Article 5 rights by failing to investigate the assault on her, given that there were a number of other investigative actions that could have been taken by the state.
Such as?
For example, interviewing the witnesses, recording the complaint in detail, and filling out and filing an official report on the complaint. These investigative actions have been codified by other state parties to the American Convention on Human Rights. For example, both Brazil and Argentina include interviewing the victims and witnesses as key actions to be taken when a report is made.
But other than Argentina and Brazil, what do other states have? I mean, if we look at the practice of states, doesn't it vary according to the ability of the state to actually marshal the resources in that direction?
Your Excellency, we agree that the investigative framework of each state is dependent on the resources that they have.
Mm-hmm.
In the present case, there's no indication that the police were unable to spare the manpower to interview Maria Quispe when the assault took place. And
well, again, it's about the difficulty of looking at the specific case as opposed to the framework, right? Because it is not until this case that the failings in the framework appear to have surfaced, and it appears that the only failing in the framework is that the only medical examiner in the area was out of town so that she could not undergo the required medical examination. So it is her own delay, right? Because she then waited 4 months to be further accosted by Jorge Perez before she went and filed another complaint, where surely the only medical examiner not being available means that she should take it upon herself to go and get a medical report from someone else if it is a matter of urgency.
Your Excellency, is unclear on the facts whether or not there were other medical examiners available in the area.
See, the point here is that it's quite a severe injury. It is a disfiguring with a broken bottle, right? And to be honest, even in our domestic courts, there are situations in which very severe injuries are not actually sort of taken into account in a personal protection order kind of application, where the victim himself or herself does not avail herself of the opportunities to gather evidence in her favor, right? So in this situation, you can't expect the prosecutor or the investigators of the police to be so paternalistic as to take action when there's a police report without the backing of a medical certificate. So we are aware now, but the point really is that the delay of 4 months in between the first report and the second attack really is something that should be attributable to Ms. Quispe rather than anyone else.
Your Excellency, we dispute that Ms. Quispe should take responsibility for failing to get a medical examination for 2 reasons. First, she lives in a situation of poverty. And second, it does not make sense that the state's obligation to investigate should be contingent on whether or not a medical examiner wishes to take a vacation or not.
Well, that relates to the structure and the system that is set up, right? and also the resources of the state in making available medical examiners, isn't it? So where does the balance lie? Should we punish a state for not having the resources available, or should we say that this is a regrettable incident, but because of the framework of the that is available in the state, things should be done to change the framework, but the specific remedy that is available to Ms. Kispe here, unfortunately, cannot be granted because there is actually no breach of the human rights obligations, because those cannot actually be so absolute as to not take into account the specific requirements of the country or of the jurisdiction.
Your Excellency, I note that I've run out of time, and I will answer your question before concluding my submissions.
Yes.
Your Excellency, is our submission that although the framework that is faulty, right, and that was addressed in our memo submissions, in this particular instance, Maria Kispe should still have recourse to this court because, firstly, the obligations on the state are treaty obligations which it itself signed up to. Secondly, that this obligation is one of means and not results. And in this case, the state cannot point to any action that it took, any means whatsoever to investigate this assault, purely because the medical examiner was away. If I may be of no further assistance to this.
Thank you.